just do a quick introduction. Ronee Steiner is a judge for Maricopa Superior Courts, correct?
Correct.
And Steve Silverman is a lawyer that both of them are going to be talking about merit selection for judges. The one thing that I know about it, that I think most of us are knowledgeable just with this part, we look at our ballot and there's a lot of judges on a list, and you're supposed to know who did well throughout the year and who did not. And that is part of the merit selection, sort of keeping them in their places. And I think that's going to be part of what they are going to be speaking about. So I'm going to yield the floor to Ronee and to Steve. And again, thank you guys both so much for your time today and for your presentation.
Of course. Thank you so much. It's good to be here with everybody under these circumstances. I am a judge of Superior Court in Maricopa County. I was appointed by Governor Ducey just about 5 years ago. I was a practicing lawyer here in Arizona. Moved out here and took the bar in 1995 from New Jersey and Pennsylvania. And so I was appointed 5 years ago. I was in the family department for 4 years. I have been in the criminal department. June will be 1 year. I know Steve, and why I brought him in is two separate issues. I've known Steve for quite some time. His wife was actually a commissioner in the Superior Court, where I got to know her professionally. Stephen actually officed with me and some other lawyers before I became a judge. I got to know him. Now, Steve is a member of our Judicial Nominating Commission as an attorney member, which we'll talk about in a few minutes. So I thought it would be really important to have him participate in this process and share his information and perspective to all of you. It is true, a lot of people don't know much about what we do in terms of how judges become judges in Arizona, and merit selection is an incredibly important part of our judicial process in this state. And I think it's really important that people know and understand more about it. So I'm going to go to some slides, and Steve, actually, Steve, I'm going to pull up the slides. If you would just introduce yourself for a minute, that would be great.
Yeah, sorry, I just had a phone call pop up and like screen went blank. I've not Zoomed before. My name is Steve Silverman. I'm a attorney member on the Maricopa County Commission. I've been a member for 3 years. There's the commission is comprised of a total of 5 attorney members and 10 lay members. And I'm sorry?
No, I'm going to Zoom people. I'm going to mute people. That's someone just chiming in and talking.
Oh, okay. And the way that the merit selection process works, the ballot that people see, that's something that's part of a process that occurs much further on down the road. The merit selection started in 1974. The idea behind it was to have a non-partisan system where merit is the primary consideration, and the goal of which was to reduce as much as possible the politics or the partisan politics that you would get if you had contested elections with partisan registration. And I think that currently in Arizona, Coconino County opted into merit selection. Pinal County, Pima County, and Maricopa County all meet the minimum population threshold for it. And the way that the process works in short description is that we will have a period of time once we are told there's a vacancy where we will recruit applicants. People will apply. The applications themselves for current positions are available on the website that is maintained by the Administrative Office of the Courts. We will have 2 meetings that take place. One is to determine who's going to get an interview, and then about a month or so after that meeting, we will, after we interview candidates, we will send up to the governor a list of nominees. The governor then will make an appointment off of the list that we send to him or to her, and there's some technical, or not technical issues, but there's some timing questions with respect to when we have to meet and when we have to send names up and when the governor has to respond. That's probably a little bit too much into the weeds, but the big picture from the merit selection process is that the process is is much more open when it comes to the applicants and the information about applicants. There are lots of opportunities for people to participate and to let their opinions be heard by the commission. And then following, and so between the applications, the information being available, and we conduct the majority or the vast majority of our deliberations are conducted in public. And so when we are weighing applicants and determining who's going to get an interview, who's going to be a nominee, we do that all publicly. And typically we do, our meetings are usually at the Supreme Court building. We're currently in a process where we're filling a vacancy, and because of the circumstances, we're first time that I've ever heard of this happening since I've been a lawyer. We're going to have our screening meeting via telephone. So that's on Thursday. If anybody is really interested in listening in on the meeting, I could separately provide the information for the public to call in for the meeting. So that's the mechanics of it. With the idea behind having it being weighed toward lay members is to really encourage the participation of the broadest segment of the community as possible. And we look to try to put onto the bench or give to the governor the opportunity of appointing the best applicants, regardless of partisan considerations and other political considerations. And so that's the nutshell of it. I think something like merit selection and the other aspects of the judicial process, in a lot of ways, when you don't hear anything about it, it is an indication that it's working well. And so that's what we do. We were one of the first states to implement it, and we don't hear a lot about judicial political controversies involving the judiciary. There's just fortunately very few here. In jurisdictions where they have partisan elections for judges and for appellate judges, the kind of rancor that exists in other branches and other segments of the body politic will carry over into the judiciary. And in our process, under the current governor's administration, just looking at the trial court numbers, which for Maricopa County, which I'm most familiar with, I think this has been as nonpartisan a process as it ever has been. This governor appoints out of his party. In other words, a non-Republican gets appointed nearly half the time. We do have there are some rules that relate to partisan politics. Those are designed to make sure that the minority party, sorry about that, I don't know how to disable that. We have to send a certain number. We can't have more than, I think it's 60% of the same party. And the reason behind that was to prevent partisan slates from getting sent up. And in practice, not so much now, but when I first got onto the commission, there were times when we had more Democrats that wanted to send up that we could because of the way that the minimum requirements was. In other words, we had to send up fewer Democrats than we wanted to because of the requirements to have balanced political lists. So that's kind of some of the bigger concepts that operate behind merit selection. Once somebody is appointed, they end up then on every 4 years we'll show up for a retention election. And
Let me jump in. Can I jump in on that, Steve?
Absolutely. Thank you for interrupting.
No, it's okay. So I just wanted to back up a little bit. I'm going to share some slides with everybody. Just a lot of this Steve just touched on, but I just as history, actually the Arizona Constitution was modified. So in 1910, it provided for Arizona judges to be chosen in nonpartisan elections, and for vacancy vacancies in judicial offices to be filled by a gubernatorial appointment in the next election. The problem was, as Steve touched on it, you know, as you just understand by watching any type of politics, politics brings politics, right? And so the goal was to create a merit-based election system over time to increase the quality of the judiciary. There was obviously arguments from both sides. One was, you know, we're going to place these decisions in special interest groups' hands. The other side who was saying, well, I mean, we can avoid that if we make it transparent. So there's obviously a lot of problem with elections. I mean, campaigning is cost prohibitive, and by the way, the smaller counties in this state still do have elections. So, you know, it's cost prohibitive for judges. You tend to get fewer of those higher level big firm, you know, very experienced people, because they're just not going to put themselves in a position to be campaigning. So we passed the merit selection process, and then over time, things have changed. But I think it's really important, as Steve pointed out, to say that it really just helped tremendously to help make things more transparent. I have a slide here. Steve touched on this in terms of who makes up that commission. And so, you know, this vetting process is very intense, and I can tell you that from the other perspective. So Steve has a perspective of the commission, having applied for the bench and been appointed. There is a very rigorous application process, and once you submit that application, the commission determines whether to interview you. When they interview you, that's what Steve was talking about in terms of that process. So they're made up of attorney members, non-attorney members. So people like you all who are members of the community can apply to be on the commission. And then the chairperson is a Chief Justice of Arizona Supreme Court, or his or her designee. And then they work in term periods. And I believe it's still 4 years, correct, Steve?
Yeah.
And so I'm not going to belabor what Steve explained during the process, so that you go through this process, and ultimately they make the recommendation to the governor as to potential appointees, and then it's up to the governor's office. Now, mind you, during this process, the commission is receiving input from people. I mean, they have somebody is assigned to look into, do the due diligence, if you will, for the different applicants, and so they're getting information that obviously people can go speak to the commission, and then ultimately the commission makes the recommendations. The same thing happens at the gubernatorial level, and that is that his staff does due diligence as well. They get input. People can write letters of support or give negative remarks if there are. And then ultimately the governor makes the selection with the help of his staff. It's really different now. When I got appointed, I met directly with the governor, which I think was really good for me. It was the most intense interview I've ever had in my entire career of any kind. He's definitely a CEO looking for somebody as if they were working for him personally and his staff. I mean, it was very intense, a lot of constitutional based questions, your judicial perspective on things, your philosophy as a judge. And it was a very intense interview. Now, they have modified the process a little bit, which requires there's actually an additional writing sample that you're required to provide, and then also there is a meeting with his staff, his chief counsel, his chief of staff, and a few other people he designates to then ultimately give him a opinion about different people, but ultimately it's unequivocally his choice. And so there's a balancing going on here, and that's what makes this process so amazing. And to touch on what Steve said, also why you just generally don't hear about these things is because this process is so excellent. It is the due diligence that commission goes through with applicants, and then the governor's staff goes through, is you are whittling down to the type of people you would hope and expect to be on your bench in your county. I mean, that's you know, that's why the process works so well. And so let's see some additional information for you. The governor has to appoint someone within 60 days of getting the nominees. He's actually about to hit 60 days this week, actually, for 2 openings. So you probably could go on his website in the next week and find out the names of the 2 next nominees, or the 2 next appointees. And so that's basically how that works. Now, in terms of the ballot, I'm sure many of you have seen judges' names on the ballots over the years and wondered, what am I doing? Sadly, very sadly, there are people who go through that list and they just check no. I do not know the mentality exactly, because I can tell you I was on the ballot 2 years ago and there were, let's just say, 1 million votes. There are about 700,000 yes votes and 300,000 no votes. I can tell you without question, I have not had 300,000 people in front of me. To me, there is not very good reason to vote no for me, but people have a right to do what they want. The reality is this is not an election where I'm out campaigning. The process is a neutral peer and community review called Jpr, Judicial Performance Review. So during this period of Judicial Performance Review, JPR, all litigants, lawyers, people who are in the court, like staff, clerks, court reporters, anybody like that, jurors, all have an opportunity to respond to a survey, and that survey is sent anonymously. It is set up by an out-of-state process. They compile all the results and then ultimately provide the data to the bench. And then there is the Judicial Performance Committee that basically looks at all that information, and if they have any questions or concerns about any of the judges' results, they might call you in front of them and ask to explain some things. And then they ultimately will recommend a yes vote or a no vote to the public. I will tell you, I can't tell you the numbers of how many judges in the last 40 years have been recommended for no votes. I will tell you, in the last 5 or 6 years, I'm aware of 2 recommended no votes. That's it. And in the last 40 years, you can see my slide here, how many judges have not been retained in approximately 40 years? The answer is 2. And I say 2, why? Because merit selection, that's out the cream of the crop, and Judicial Performance Review allows assessment of issues and for judges to work on issues such as administrative treatment of their calendars and so forth. So when you see judges' names on the ballot, that's what is going on. They're on the ballot because the Constitution requires it, and it also allows for the public to have input on those judges. You can get all that information on the Arizona Supreme Court website. So when you get close to the election time, you can see who's recommended to have a yes vote or no vote. If you're a member of a particular party, I have seen lists that get passed around by the Democratic Party, the Republican Party. Hey, here are the people you should vote yes for, people you should vote no for. You could find lists out there by lots of organizations, very conservative, more liberal organizations who will tell members of the parties, hey, here's the people you should vote yes or no for. But my attitude is do your own research. There is a reason why merit selection works so well, and that is because the governor is appointing people who are quality judges. And if you rely on the D, the R, the I, or whatever it is somebody chooses to be, then you may not be doing the community yourselves a service and looking at it. And that's why I think Steve's points about the number of judges appointed outside of the governor's party being so high is so important, because the governor's people of the state should always want the best quality people sitting on the bench, and not be hyper-focused or focused at all on the fact of somebody's political affiliation, particularly at the Superior Court level. I understand as higher up in the Supreme Court, perhaps, where they're resolving major constitutional issues, things like that, where somebody might be more focused on it. But so, Steve, I don't know if there's anything else you want to add in there. I know I just talked a lot.
Sure. With respect to the question of the retention elections and candidates who are not, my recollection is consistent with yours, Judge, that there are two judges who were not retained, and one I think was in the I believe it was in the 1970s, and it was a Court of Appeals judge who had authored an unpopular decision on busing and desegregation. And then the more recent was a judge who had administrative issues with the way that the calendar was run, and it received a do not retain recommendation from the Jpr committee, and then wasn't retained. And that's, and so some people will look at that and say, well, the retention election system is not working, because if we've only had two people who were no votes, then we're not throwing enough judges off the bench. And there's a lot of other parts of the judiciary that are in play, that before somebody is going to be seriously faced with an issue about getting retained or not, that come into play. And there's a commission on judicial conduct, and there are a number of people who have retired early because of concerns that are raised in the discipline process. So somebody who's not familiar with the judiciary and thinks that there's, if we've only voted one person off recently, this process doesn't work. There's by the time you get to that point, there's a number of processes in place that protect the system. So, for example, if you've got a judge, if we've made a mistake in who we've nominated and somebody is not able to do the job, they will get a lot of counseling from the court. Initially, they will get counseling as part of the Jpr process. So there's a lot that goes into protecting the public that isn't just the election. It's not just the merit selection process. The biggest controversies or issues that we've faced since I've been on the commission have concern, it's what in the, and if this is too much like inside baseball, I could talk about things that are more generally applicable. But with respect to negative information that comes in, the commission's changed the rules and tried to tighten the rules, and this happened before I was on the commission, related to confidential and anonymous criticism. We're supposed to verify anything that's critical. We're supposed to get it directly from the source. If there's anonymous information that's negative, so if somebody just were to send in a unsigned letter that had negative information about a candidate, that's not going to be something that the rules are going to recognize as being an appropriate basis for making a decision. In practice, and this is new, I think, as a matter of operating policy, is that if we receive negative information about a candidate and it's material to the commission, we will ask the candidate about it when the candidate interviews. And we have, with respect to any one commission meeting, we may go into executive session for one or two or three small discrete matters. So depending on the nature of the information, the candidate would also have the opportunity to answer something in private. Now, we've had people who have spoken out against candidates, and we will fully vet the information that comes in. If there are lawyers who are watching this and they're thinking about applying for the process, we understand that the practice of law can be you're not always going to go along with everybody. And if there's one or two people and we have really strong feelings, we will evaluate the whole circumstances of it. It's not uncommon that there's a handful of people who will have negative information about a candidate. I've had it come up where people who I've known for a long time will say something to me about a particular candidate. And after I'm done evaluating it, even though I trust the source and I don't think there's anything dishonest about what the person is relaying to me, that I will come to the conclusion that the information that was reported isn't germane to holding somebody's application process up. So we've had issues with, and we've had issues with how anonymous information is dealt with, or how something that somebody wants to, talk about an opinion that's a negative opinion. We try to look very carefully at the basis for it, and most importantly, afford due process on the candidate side of it.
Does anybody have any questions?
I do.
I just unmuted everyone, so if anyone has any questions, please chime in.
I have a question. We get these booklets that have all of the information on what's going to be on the ballot, including all the information on the judges. And one of the things that isn't included in there is, I guess, I don't know how you would say it, biased opinions. It's just, there's so little to go on when you're trying to say yay or nay on any one person, that it's just, you just have a tendency to go through and either go by your party or go by, or just checking off yes to everybody or no to everybody. But it's just that booklet doesn't give you enough to know whether a judge is, plus you don't get this court is responsible for these kind of cases. So you know that when you're looking at a judge, they're going to be looking at cases that are specific to certain legal matters.
Well,
And that's,
let me try to bring that back to one of the comments I'm trying to make about the information and what Steve was saying about what has gone on by the point that you have got a ballot and then judges' names are on the ballot. The information, I don't control certainly what's in the booklets. I'm not even sure exactly who puts that together, but if you do look in the book, you will see a couple of things. One of which is if they're recommending a yes retention vote or a no retention vote, okay? And that's incredibly important, because the reason why they'd be recommending a no vote would be that this judge has significant issues. Something has gone on with this judge that they believe could not or would not be corrected, that makes this judge questionable to be retained, for 4 more years. The other is percentages. So you'll see, well, actually, no, I take that back. I'm not sure that that's in the book. So all the information is public. If I recall correctly, it's on the Arizona Supreme Court site. If they were to give you a book with every single piece of data, the books would be 10 phone books worth. I mean, that's the reality. So that they try to boil it down and provide you, the basic information. I'm not going to sit here and say, hey, if there's a yes vote, you should vote yes. That's your job to decide as members of the public. What I'm just trying to explain is that, and as Steve was saying, that the process is so in-depth and works so hard to ensure that the public is protected from, somebody who's making unbiased or biased decisions, somebody's gone rogue in some way, that by the time you get a booklet that says yes vote recommended or no vote recommended, they've gone through that process. There's been a judicial, survey process on people who've come in and out of the courtroom, the jurors, the lawyers, everybody involved. They have gone through that process, and then ultimately that vote is recommended. And that's why I said, from my perspective, and obviously I'm not a great example, I'm a colleague of all these people, but if I'm a member of the public and I'm looking at vote, I want to rely on yes vote, no vote, because that information says to me that these people have continued to be vetted, and our Constitution is being protected by the fact that we're getting this ultimate information from this commission. I'm not sure. Hopefully that answered the question. Anyone else?
Thank you.
You're welcome.
Anyone else have any questions?
Hello, I just joined you, and hello, everybody.
Hello.
Myra?
Yes, it says start my video. How do I start my video?
Click OK.
Pardon me?
I guess click OK. But if not, you can ask the question without that.
That's my question.
Oh, that is your question?
That's my
Spelled it.
Did anyone have any questions for Ronnie, not for me?
Where's Steve?
Steve, did you have anything you want to add on that?
Well, the only thing that I would add to a comment that the judge made a little bit earlier is that it does seem like with every election, there's roughly 28–30% of the population that votes no on all candidates. And then what I've observed is that that people will look at the Jpr booklet, which is the ballot booklet that the person asking the question was referencing. And so if there's one or two no's, and so there are a number of candidates that will be mostly unanimous, but there'll be one or two people who have voted not to retain. And the Jpr Commission is similar to the Merit Selection Commission. It's a commission that is made up of primarily lay members. It has some attorney members on it as well. And their meetings are all in public as well. So one or two no votes. So like a 16-2 retain recommendation from the Jpr Commission, that person might end up with 35 or 40% no votes. And so it's just kind of interesting to see that block of no votes. I think, I look at that and I think that there's a number of people in the community who don't feel like the judiciary is responsive to them or answers to the concerns that they have. And I think that to some degree, there's not a lot that we can do from inside the system that we're not doing. But I do think it's worthwhile to respect the overall community sentiment. And I think overall, there's widespread support in Arizona for nonpartisan, merit-based merit selection, and so it's a source of strength for the judiciary. It's a source of strength for the state. Maricopa County has one of the country's largest court systems. It might be the fourth or fifth largest court system. There's almost 100 Superior Court judges. There's almost an equal number of Superior Court commissioners. They hear everything from family law cases to criminal cases to civil cases above $10,000. So the court is a really significantly large enterprise where there's a public oversight component to almost all of the work. If you are somebody who is involved in the process in some way because you have a family member who's got a family court case or a juvenile case, and you have your experience with the system is less than optimal, there are places to go. And the best place to start is the Supreme Court website of what the oversight and public commentary part of the process. So I just wanted to add to the judge's comments with that.
I have one question. I guess this is maybe for the judge, or both of you actually. Who's the initial introduction, or I guess for you as the Governor Ducey, but who's the person who put you on his radar?
Well, it's It's Steve, the commission. I mean, they're the ones who ultimately make the nomination. So once it gets to the commission level, once you've interviewed, they have a meeting and say, okay, these are the people we believe the governor should consider. And so that's how it works. And then once it's in the governor's hands, it's up to the governor to have his process to how he gets to the appointment. That's when I was saying I interview directly with him, with his staff, and now he does it a little bit differently.
But I mean, were you doing any, I'm going to say, were you in any capacity a judge before that? You went straight from law as a lawyer to
Right.
So how do they?
Most people do that. So I mean, we do have somebody on the bench right now who was an administrative law judge before she became appointed. But most, I'd say the high majority are practicing lawyers and they apply to the bench as a practicing lawyer.
Okay, so you had to apply first.
That's correct.
Okay, that was my question. So there was one thing, you had to initiate the process.
And that's when, and I know it was way back. So the application process is first, that very rigorous application process. It's about a 30-page application. It takes a lot of energy. You fill that out, you submit it by a deadline date, and the commission is that first step after the application. They assess the applications.
Okay, so there is that. In other words, no one plucks you out of thin air and says, "Oh, Ronnie would be a great judge." And you.
Well, I can speak to that question.
Sure.
What we do before the application process, there's a vacancy that gets announced. We have a certain period of time that we have to accept applications, have our meetings, and then send our nominees to the governor. I will spend that time in between formal recruitment processes, reaching out to people directly. But I'm doing it in my individual capacity. So I will talk to judges, I will talk to people that I've practiced with, and I'll ask them for suggestions on people who might be good candidates for judge. And at the same time, I get a number of phone calls from people who are interested in applying, and time permitting, I'll talk to them and answer their questions. So what you were asking for, there is a recruiting process that happens that's not formal. There's no rules that govern it, but it's a very important part of the process.
And is there a minimum amount of is there a minimum amount of years that a person has to be practicing to apply?
I believe it's 5 years of practice, 5 years of residency in Maricopa County, minimum of 35 years old.
Got you. Okay. So I can't apply.
Correct. And I think that's what Steve was just talking about is really important, that people like Steve who are on the commission who have those conversations, they're happening. There's probably that happens with governor staff who know people, but I think part of the focus really these days is that we really need more diversity on our bench, and we are the 4th largest trial court in the country, by the way. Maricopa County is, and it just, trying to get people to apply who may not otherwise apply is really important. And again, widening the diversity of the bench is really important as well. And so I think some of those conversations happen to try to encourage more minorities to apply for the bench who may not historically have done that.
Interesting. Thank you so much. Anyone have any other questions, or are we wrapping it up? Let me make sure everyone's unmuted. Anyone have a question? Sorry about that.
Yeah, I have a question.
Sure, go ahead,
Can you
Rhoda.
hear me? Okay.
Yeah.
In Arizona, basically what you're saying is that you self-nominate to start the process. And then it goes from there to an approval and an appointment. Are other states strictly political, or do they also do the same kind of appointing?
Well, there are many states that are purely elected judges. And so that's why we're making this distinction about Arizona. While we do have counties here that still do have elections because they don't meet the minimum population numbers. We have the merit selection in the more major counties. There are a lot of states that do not use merit selection, and you have to go fundraise and put signs up and run like anybody else. It's baffling to me. I'm not really so sure how judges really are able to be judges in the other counties. And they do a great job, but you just imagine members of your constituency who are in front of you on a divorce case or a civil case. It's tough. I can't imagine being that situation, and I feel very appreciative. I would never have run for office. It's not me, it's not who I am. So yes, in theory, I guess if you say it's self-nomination, like any other application for a job, no, but you're typically not plucked from the out in the community. You try to say, hey, I want to be considered for this job.
Are there some states perhaps where just perhaps the governor would make the appointments, have a committee to suggest people, like the federal, like the president does, where it's just strictly political? The head of the governor, the president, whatever, would make the nomination, and it would go from there. Are there places that do that?
Yes, but also in the federal system, it's similar. I mean, these people are vetted tremendously. Now, I'm not saying that there isn't more politicizing of it in federal system. Steve, you might know more about that than me, but there's been several members, several people that I know in the last few years, one member of the Superior Court, they're vetted, and they're vetted for a long time, like a year and a half through that process. So yeah, there are many states that do not use merit selection at all. And if a governor is selecting someone, then that's very likely a merit selection based process. Otherwise, it's going to be a regular election like your senators or congresspeople or mayors or anybody else.
Okay, thank you.
Any other questions? Myra Baum.
I got a question. It looks like Myra Baum posted, what are the courts doing now during the isolation? That's an excellent question. Well, a lot of things, and we've whittled down hearings to only very essential hearings. We've tried to go virtual wherever we can, which is a lot easier in areas like family court. It's very difficult and nearly impossible in some types of hearings in criminal department, which is where I am. Civil has gone to primarily virtual hearings, and that means telephonic hearings or maybe a GoToMeeting, which is similar to Zoom, things like that. We have reduced the number of people, of traffic in the courthouses by, I think the numbers were about 80%, which is tremendous. We're doing a lot of, blocking off seats when people have to come into the courtroom. We have suspended, the Chief Justice of Arizona has suspended jury trials. The most recent isn't out yet. It looks like they're going to have suspended them he'll have suspended them through June 1st. That's the newest order I hear is coming out, that right now all jury trials and juries, including grand juries, have been suspended through May.
Makes sense.
So what does that, just curious, what does that do with people who have, let's say, I'm using a lawsuit as an example, but where there's a year or 2 year window for someone to actually sue somebody, for example?
You mean like a tolling of a statute of limitations?
Yeah,
Steve, I'll let you answer that, Steve.
Courts are still open, so
Right.
there aren't any laws that I'm aware of that extend statutes of limitation.
Got you. So you're saying
you
they
can
have to
still
put that
file
paperwork in.
actions.
Got you. You're saying the actual hearing or whatever else might be postponed, but once you've already put it into process, that's all you need to do.
Yeah. And most civil cases, the hearings are, at least in my experience, are scheduled for telephonic hearings anyway. So more often than not, even before this, we would appear in court on contested matters on the phone anyway.
Interesting. All right. Any last questions? Bob, are you trying to ask something? Hold on, let me unmute you. Or unmute yourself. That might be better. There you go. All right, talk. We're not hearing you. Bob, are you speaking? If not, if you want to type it into chat, because I don't read lips. Type it into the chat. Do you see how to do that? Because we don't hear you. Your mic might not be working. Do you see the chat button on the bottom? Do you see it? I'm going to pop it up on your screen. Let me know if you see this. Did you see that pop up? A notification for chat? If not, if you email the question to me, I can make sure that they get the question. We can get the answer to you. And I'm happy to troubleshoot your mic with you afterwards. All right. He's quitting on that. Any other questions? All right. Thank you both so much. I personally appreciate this presentation. For me, it's always when the election ballot comes out, I'm looking through the lists. I go to the Arizona Republic. They usually post who's been given that, who should not be voted for, and everyone else is yes. I think most times it's one or two, like you mentioned. So if even, but I've always understood it was peer reviewed. In addition to people that sat through court cases, litigants, and everyone else. So thank you so much.
My pleasure.
And anyone else who would like to stay on and schmooze, as we always do after these gatherings, you're welcome to stay on, and we can chat, see how everyone's pace-offs were. Thank you.
You're welcome. Thanks,
both.
Steve.
Thank you.
Thank you.